Hello everyone. Today we are going to discuss about Mental Health Care Act of 2017. I'm Dr. Suresh Bada, Professor of Psychiatry, Head of Telemedicine Center, Head of Forensic Psychiatry Unit, working at NIMANS, Bangalore. Before I start my presentation, I would like to have a disclaimer. This presentation is for academic purpose only, not for legal opinion. If you want to have a legal opinion, please do contact an advocate. Conflict of interest? None. First and the foremost, why we required new Mental Health Care Act 2017. One of the main reasons is India ratified the United Convention for Rights of Persons with Disability. This UNCRPD was ratified on October 2007. Once we ratify our United Nations Convention, we need to amend our local laws and align with the UNCRPD. Hence, an exercise was undertaken to see whether the Mental Health Act of 1987 aligned with the 2007 UNCRPD. Unfortunately, the Mental Health Act of 1987 did not provide any kinds of rights and protect and promote the human rights of persons with mental illness. Hence, a task was undertaken to amend the Mental Health Act of 1987, and it was found that it was almost writing a new law. Hence, a new law was planned. That was Mental Health Care Act of 2017. But however, the Mental Health Care Act, although it has been recently planned in 2017, the mental health care in our country has come a long way with the paradigm shift. First and the foremost, Indian Lunacy Act of 1912. When this law was there and it was planned, it was only custodial care for persons with mental illness. That means there was no treatment. However, post-independence, Mental Health Act of 1987 focused mainly on the treatment, but human rights were completely ignored. Hence, the new legislation aligning with the UNCRPD planned providing care and services under the realm of providing human rights. That means you need to provide care with protection and promotion of human rights. Hence, new Mental Health Care Act 2017 was planned. The Mental Health Care Act of 2017 was received assent on 7th of April 2017 by the President of India. At the same time, we also need to remember that is exactly 14 months from that, 29th May 2018, the Government of India clearly said that Mental Health Care Act 2017 came into force. That is on 29th May 2018. On the same day, three important laws, basically rules, were also planned and drafted and notified. 29th May 2018, the three important rules were Mental Health Care Rules 2018 for rights of persons with mental illness under Section 121. That is one. Second one was Mental Health Care Rules 2018 for Central Mental Authority and Mental Health Review Board. The third one was Mental Health Care Rules for state mental authorities, that is under Section 121, subsection 1 and 4. So these are the three important rules were also notified on 29th May 2018. At the same time, on 16th August 2019, there are two important notifications was also made. One was guidance document for mental capacity assessment under Section 81 of the legislation was also notified, and also essential psychotropic drugs were notified under Section 18, subsection 10. So these important landmarks also to be remembered. Further, recently on 18 December 2020, Central Mental Health Regulations were also notified. So these are the important timeline you should remember. At present, the Mental Health Care Act is in force. There are rules have been notified, regulations notified, and also guidance document, and also essential psychotropic drugs have also been notified. Moving further, the Mental Health Care Act 2017 has 16 chapters and 126 sections. The preamble of this legislation is very clear. It has two important objectives. First and the foremost is providing mental health care services for persons with mental illness. And the second important is to protect, promote, and fulfill the rights of persons with mental illness during the delivery of healthcare services. So these are the two important objectives the Mental Health Care Act of 2017 planned and implemented. The heart and soul of the Act revolves in Section 5, that is basically Chapter 5, from 18 to 28 section, and it clearly articulated the rights of persons with mental illness. So that is the reason I call it as heart and soul of the Act. It starts from Section 18 to Section 28. Let's see what are those heart and soul of this legislation. First and the foremost, capacity assessment. That is in Section 4. Advance Directive, Section 5 to 13. Nominated representative, Section 14 to 17. And rights of persons with mental illness, Section 18 to 28. So these are the important points, and the section clauses have been drafted and notified under this legislation. Let's see each one of them. Let's look into the mental capacity. As per the Section 4, it's very clear. It says that every person being an adult has capacity unless proven. That means the law says everybody has capacity. If you say that he doesn't have capacity and would like to treat him against his wish and will, that you need to prove that the person do not have all these three. That is comprehension, understanding the information that is relevant to take the decision for treatment, admission, and personal assistance. That means he does not have comprehension, or else is unable to weigh the risk, appreciate any forcible consequences of lack of decision, or making a decision, that is accepting treatment, refusing treatment, what are the risks and benefits. He is unable to do that. And finally, communicating the decision. If he is unable to do this, then only it will be considered as lack of capacity. Then only the nominated representative will support the patient, and the NR signature is more than enough to provide treatment against his wish and will. However, it is not completely proxy decision making. It is supported decision making. Hence, Section 4 is an important pivotal role plays in the legislation. Hence, every point of time, whenever you want to do something against the persons with mental illness, against their wish and will, against their consent, capacity assessment is must. And capacity assessment guidance document has been notified under Section 81, subsection 1. Moving further, advance directives, Section 5 to 13. Advance directive is basically any adult would like to write in writing that how he should be cared and how he should not be cared. That means every person, every adult has a right to make an advance directives in writing. How he should be cared, how he should not be cared, and also he can nominate some of the nominated representative if he loses capacity. And this advance directives should be in writing and should be registered with Mental Health Review Board. Further, it has to be clearly understood advance directive shall be invoked only when the person loses capacity. That means Section 4, if a person loses his capacity, then you need to go and look into the advance directives. What the person has written, how he should be cared, how he should not be cared, and who are the NR which has been notified under this advance directive. And this advance directive is basically for mental health care only, not for any other purpose. It is only providing care and treatment for admission, for treatment purpose and rehabilitation purpose. And if any advance directives, if somebody has written anything contrary to the law, will become null and void. At the same time, once advance directive is written, it is not permanent. It can be revoked by the person by himself, or else Mental Health Review Board can also amend the advance directives if the family members challenges the advance directives in the court of law, that is in the Mental Health Review Board. Further, it's very clear, once the advance directive is registered under Mental Health Review Board and a person's has a mental illness, then it is the responsibility of the patient or the nominated representative to provide the copy of an advance directive to the psychiatrist. And the psychiatrist will be duty bound to follow the advance directives. Advance directives will not be followed during emergency treatment. And it has to be followed once the capacity is lost. Hence, a capacity assessment is must. And also, it is very clearly written, a medical practitioner or a psychiatrist shall not be held responsible for unforeseen consequences of following the advance directive. For example, if the patient has written that he has to be given haloperidol injection, and if the doctor follows that advance directives by giving injection haloperidol and the patients develop side effects, the doctor will not be held responsible. The doctor will be just following the advance directives. Coming to the nominated representative under section 14 to 17. Every adult shall have a right to appoint a nominated representative. Nominated representative, the patient can choose either the friends, family members, or any person whom he likes, but he should be again a major. And NR who is being chosen should also accept the responsibility under the legislation, and it has to be registered under the Mental Health Review Board. If there is no NR has been nominated by the persons with mental illness, and these are the following people, it will be considered by the Mental Health Review Board. And the law clearly says if the patient has not nominated anybody, then the relatives will be the first as a NR, that is family members. The next one is caregivers, paid, non-paid, or family members. Suitable persons appointed by the Mental Health Review Board, or else if there is nobody is there and a person is wandering mentally ill, then it can be a director of the social welfare, Department of Social Welfare, the director will be considered, or else an NGO can be nominated by the MHRB for the purpose of this act. And also you should remember roles and responsibilities of the NR. The NR, by deciding the patient's current, past wishes, life history, values, cultural background, and in the best interest of the persons with mental illness, he will support the person with mental illness with regard to admission, treatment, rehabilitation. That is basically for mental health care purpose only. Further, he can seek information under what section the person is admitted. He can approach the Mental Health Review Board on behalf of the patient, and also to appoint a suitable attendant in the hospital for providing care. And also, the NR can give consent for research. But please do remember, NR has a responsibility in providing the consent when the patient has lost the capacity to consent. Moving to the important point, that is rights of persons with mental illness. That is section 18 to 28. This is the heart and soul of Mental Health Care Act. Let's see what are those. Section 18. Rights of persons with mental illness. Section 18 clearly talks about right to access for mental health care. That means the state has a responsibility to provide all type of mental health services, that is inpatient, outpatient, and rehabilitation services, and it should be affordable cost, quality, and quantity. If the right to access for mental health care is not available from community health center and upwards, that is taluka level and district level, the compensation has to be provided to persons with mental illness for seeking treatment somewhere else. That means the government has taken up the responsibility. And also, free treatment has to be given for the below poverty line patients or the destitutes. And also, here, right to access for treatment also means long-term care like rehabilitation services, supported accommodation, and sheltered accommodation has also been mentioned. Moving to the section 20, right to protection from cruel, inhuman, degrading treatment. If you look at the quality assurance publication by NIMANS, clearly said that persons with mental illness in mental asylum or in the mental hospital was very, very bad. That means it was in a inhuman condition. Hence, this quality assurance came up with various recommendations which was upheld by the Supreme Court. Hence, these are the recommendations which have become a part of the Mental Health Care Act. First and the foremost is safe and hygienic environment for persons with mental illness in the mental hospital, adequate sanitary condition, leisure, recreational, education, and religious practices within the mental hospital, privacy and clothing, not to be forced to undertake any work in the mental health establishment. However, if he is being provided some rehabilitation for the purpose of reinforcement, some remuneration to be given, and that remuneration should be equally across all persons with mental illness. Adequate provisions for preparing for living in community also to be planned. And also, persons with mental illness, when they are in the hospital, wholesome food, article for personal hygiene, and particularly women's personal hygiene is very essential. Sanitary napkins to be provided. However, still in many of the government hospital, sanitary napkins are still not being provided. However, this is a very important right. And also, in various mental health hospitals, tonsuring was a common by default. But however, this law clearly said that no compulsory tonsuring. The shaving of the head can be done only for the purpose of hygiene, where a person had complete matted hairs and it is dangerous for his health. And persons with mental illness shall be free to have their own clothes and wear their own clothes, not to have the hospital provided uniforms. If the patient can choose either one of them, to be protected from physical, verbal, emotional, and sexual abuse within the mental hospitals. The next section 21 is right to equality and non discrimination. That means the law clearly says mental health cannot be ignored, discriminated from the physical health. It has to be kept in an equal pedestal with the physical health. And also, the obligation has been casted upon each state government to provide emergency facilities like ambulances, adequate appropriate living conditions similar to physical illness. That means now the state government has gone one step ahead for providing emergency treatment similar to physical illness. And also, the insurance, health insurance cannot be denied just because he has mental illness. That discrimination is not allowed. Further, right to information under Section 22. As per this Act, persons with mental illness and his nominated representative has a right to receive information with regard to admission, under what section he has been admitted, what is the admission procedure, what is the treatment chosen, and the information provided should be in the language of the patient. That is Section 22. Moving to the right to confidentiality, Section 23. This is a very important right which has been enumerated. It is the duty to keep all the information received during the treatment purposes should be kept confidential. Only person with mental illness has a right to know about his illness and to be given to him only, not to anybody else. And if he has lost capacity, only to the person the NR should be given. Otherwise, the duty of all healthcare providers to keep the information of persons with mental illness confidential. However, the exceptions, what has been clearly mentioned, is the information can be given to the nominated representatives if the patient is referred to other hospitals, to other mental health professional or health professional for providing treatment. If the person is very dangerous to others, so that person who is relevant, who is at the risk of getting harmed, should be informed. In medical emergency, in the interest of public safety and security. Finally, in the judicial proceedings, these are the situation when a psychiatrist can break the confidentiality. Otherwise, under no circumstances, the mental health professional is going to break the confidentiality or privacy. Right to access for medical records under Section 25. All persons with mental illness shall have the right to access for basic medical record. The basic medical records have been clearly said in Form B of the Mental Health Care Act Rules 2018. Form B, where it has an outpatient basic medical record, inpatient basic medical record, and also clearly talks about if a therapy is done, what are the records and therapy session notes to be kept. And if the person with mental illness requests for this record, all mental health professionals need to give the basic medical record to the patient only, not to anybody else. If the mental health professional feels that he cannot be given this information, if the information is given, it will harm him or somebody else, those information can be withheld and also given in writing that he has a right to appeal to the Mental Health Review Board to access for the medical records. So here it is right to access for basic medical record, not the complete file. If the patient wants a complete file, then you need to approach the Mental Health Review Board if there is a complete file is kept. Usually, a comprehensive file is kept in academic institutions for the purpose of teaching. However, in the general hospitals or in the corporate hospital, they will maximum keep basic medical records. So the patient has right to access for basic medical records. Nobody else has. Even the nominated representative do not have this right. Only persons with mental illness has these rights. Coming to rights of persons with mental illness further, it talks about section 19 for right to community living. Just because a person is ill or persons with mental illness can be kept in asylum, no. Every person has right to community living. And also section 27 talks about right to legal aid. And also right to restriction on release of information in respect to mental illness is section 24. And also right to personal contact and communication in section 26. Basically, if a person with mental illness has been in the hospital, he has all the right to keep his mobile phone. However, he is not going to disturb any other patients, and he has to follow the rules of the hospital. That means reasonable restriction is allowed, not a blanket restriction. At the same time, right to make complaint and deficiency in provision of services are provided under section 28. All mental health establishment need to provide this redressal mechanism within the mental health establishment. Now, moving further to the implementing authorities. Till now, we spoke about rights of the persons with mental illness. Now, these rights need to be implemented. So, there are three important implementing authorities which have been notified under the legislation. First and the foremost is Central Mental Authority, which have been clearly mentioned from Section 33 to Section 44. State Mental Authority from Section 45 to 56. And finally, the Mental Health Review Board, Section 73 to 84. Mental Health Review Board is a quasi-judicial body which is going to regulate the professionals and also regulate how the patient is admitted and also protects the rights of persons with mental illness. And also in the review board, it is the registration of advance directives and nominated representatives do occur here. Coming to the mental health establishment. Mental health establishment is nothing but mental hospitals. Basically, the definition of mental health establishment under Mental Health Care Act means anything, any structure where a residential place apart from the family of the person with mental illness will be considered as mental health establishment where a person is going to stay overnight. And those establishments need to be registered under the state mental health authority if it is in the state. If it is being financed predominantly by the central government, it will be registered under Central Mental Authority. There are two types of registration. One is provisional registration, another one is permanent registration. Provisional registration is done either in the Central Mental Authority or in the State Mental Authority, respectively where they belong, until the minimum norms are notified. Once the minimum norms are notified, then they have to be registered as permanent registration. By chance, if the registration has been sent to the authority, either the Central Mental Authority or the State Mental Authority by the respective establishment, and they do not communicate, that means it is deemed to be registered. That means they have to communicate within 30 days. If they don't do it, they are deemed to be registered under this legislation. If a person, a psychiatrist, is aggrieved because the state authority or the central authority do not give permission, then he can appeal to the High Court within 30 days. Coming to the admission. Admission of persons with mental illness into the mental health establishment. Please do remember there are two types of admissions. One is voluntary admission, also called as independent admission. Involuntary admission, also called as supported admission. Basically, both are, there are new names being given. It would have been appropriate, it would have been kept as voluntary and involuntary. But however, let's go with the newer terms like independent admission. Independent admission, there are two types, again, for adults and minor. Under Section 86, an adult patient who has capacity will approach the mental health professional or else to the medical officer of the mental health establishment, request that he is suffering from mental illness and he wants treatment and he needs to be admitted. The medical officer in charge will examine him and feels that by admission he is going to benefit, he will admit him. That is Section 86. However, Section 87 for the purpose of this legislation is for minors. Here, the nominated representatives, that is basically parents, will request the psychiatrist or else the mental health professional or the medical officer in charge for the admission and treatment of minor. And once they have to be admitted, one doctor and a psychiatrist and a mental health professional, any of these two, will examine independently and admit him to the mental health establishment. Moving to the supported admission, it is also called as involuntary admission. Involuntary admission, there are two types: Section 89, Section 90. Section 89, supported admission for the period of 30 days, that is up to 30 days only. If it crosses more than 30 days, it has to be shifted to Section 90. That means any person who has to be kept more than 30 days, Section 90 will be applicable. Here, under Section 89, a nominated representative will fill the form and request the medical officer or the psychiatrist in charge of the hospital for admission. The psychiatrist will examine him and also will request another mental health professional for the examination. Both the parties, basically both the mental health professional and psychiatrist, need to agree and to come to the same conclusion that he needs admission. Then only he can be kept against his wish and against his informed consent. From the consent from the NR can be admitted to the hospital for a period of 30 days. That is Section 89. If it has to be crossed for more than 30 days, under Section 90, two psychiatrists has to sign for him to keep for longer duration. However, in both the situation, Mental Health Review Board needs to be informed that they have been admitted under this legislation in the mental health establishment. Again, you can see the independent admissions. As I said, Section 86 for adult, Section 87 for minor. Adult request for admission by himself. The medical officer will examine him and if satisfied, he will admit. Within 72 hours, it has to be intimated to the Mental Health Review Board. For women and children, for 1 week for the adult male. For the minor, request from the NR, and patient will be admitted if two psychiatrists or a medical officer and a mental health professional or a psychiatrist examined him and feels that he needs to be admitted to the mental health establishment, and within 72 hours need to be informed to the Mental Health Review Board. Moving to the supported admission. Again, as I mentioned, Section 89 for less than 30 days, Section 90 for more than 30 days. Request by NR should be there. In the first Section 89, it will be psychiatrist and a mental health professional. In the Section 90, two psychiatrists has to examine him and say that he needs admission. Again, the Mental Health Review Board needs to be informed. Coming to the emergency treatment, that is, which I discussed till now as admission. If the person is in the community and he becomes violent, what to be done? The Mental Health Care Act has Section 94 clearly talks about emergency treatment in a community setting. That means it need not be registered, even at home, even on the road, even anywhere in the village, any part of the country. Emergency treatment can be given for a period of 72 hours. The emergency treatment should be instituted only when there is dangerous to self, to the person with mental illness, or dangerous to others, or he is destroying the property of others, and it is very serious, then only emergency treatment should be given for life-saving method only, for a period of 72 hours only, not more than that. And if the NR is available, that is nominated representative is available, consent should be taken. And emergency treatment includes treatment within at home and shifting the patient to the hospital also. That the whole period will be considered as emergency treatment. After 72 hours, the doctor has to decide whether he will admit under Section 86 if the patient gives consent and has capacity. If the patient refuses and he thinks that he needs to be admitted, Section 89 will be pressed. Coming to the prohibition and restriction. The Mental Health Care Act also prohibits certain procedures. For example, the prohibition is placed on psychosurgery, and the psychosurgery can be considered only after the consent from the person with mental illness and a mental health review board clearance to be taken. Further, Restraint has been restricted. Restraint to be used only at the last resort. De-escalation should be planned. And if there is imminent threat, the chemical that is basically providing injection should be planned. If it is not possible, the last resort will be physical restraint, and it has to be authorized by the psychiatrist in charge. Further, the prohibitions also has been placed on unmodified ECT. Nowhere in the country unmodified ECT is justifiable under any circumstances. That means unmodified ECT is banned. Seclusion is banned. Sterilization for the purpose of treatment of mental illness is completely banned. Chaining, solitary confinement is being banned. ECT in minor is prohibited, but however, the consent has to be taken from the board, and also with the NR, the ECT can be given. That means it is not banned, it is regulated. These are the prohibition and restriction. Please be very careful when you do these prohibited procedures. Take appropriate consent, take appropriate permission from mental authority and mental health review board for these above procedures. Role of police and magistrate under Mental Health Care Act. Section 100, 101, 102 has been codified for the respective responsibilities. Section 100 talks about duties of the police officer in respect to persons with mental illness. If a person is found wandering at large in the area of the police station and the police believes that he has a mental illness and risk to self and others, dangerous to self and others, and the person is unable to take care of himself, in such a scenario, the police will take the person under his custody and inform if the nominated representative is available and produce that person directly to the public mental health establishment. And in the public mental health establishment, the psychiatrist will examine him and, if required, depending upon the situation, Section 86 will be used for voluntary admission if he had mental illness, or else, if his illness is so severe, he will be admitted under Section 89. However, if there is no mental illness, then the person will be handed back to the police. Further, if the person has mental illness and there is nobody available, then it is the duty of the police officer to lodge an FIR of a missing person and to trace the family members. This is a very important duty casted upon the police to search for the family members. At the same time, the station house officer shall have a duty to trace the family members. It's very essential. Please do remember that. Further, in Section 101, reporting to the magistrate. If any person in the area believes that a person with mental illness has been ill-treated or neglected, shall report to the police. Further, even a police officer comes to know and believes a person with mental illness has been neglected or ill-treated, will take that person into custody and will produce in front of the magistrate telling that this person has been neglected and ill-treated. The magistrate will issue a report telling that please produce him in front of the magistrate. Once the person is produced in front of the magistrate will examine him and issue an order under Section 102. Section 102 is basically admitting a person with mental illness into a public health establishment. And here it is only for 10 days, not more than that. After the 10 days, the psychiatrist or the medical officer in charge of the public health establishment will decide to press Section 86 or 89 or 90 depending upon the situation. That means it is the responsibility of the medical officer after the 10 days. Coming to the penalty. See, Mental Health Care Act has been drafted and notified for the purpose of protecting the rights of persons with mental illness. So let's see the penalty. Mental health establishment, if it is not registered, under Section 107, for the first contravention, 5,000 rupees to 50,000 rupees fine will be given. If in the second contravention by the same person or the establishment, 50,000 rupees to 2 lakhs fine will be given. In the third contravention, it is 2 lakhs to 5 lakh rupees fine will be given. And this will be adjudicated by the state mental authority. Further, If a person or a mental health professional knows this establishment is not registered and he works there by knowingly, then 25,000 rupees fine will be charged to the person who is working there. Basically, mental health professionals. This is under section 107. Coming to the section 108. If there is any contravention of this legislation by any person, there will be a imprisonment for up to 6 months with or without fine of 10,000 rupees. If there is a subsequent second contravention is there, the punishment will go up to 2 years and fine from 50,000 to 5 lakh rupees fine will be done under section 108. Decriminalizing the suicide. Section 115 of the Act took a landmark paradigm shift where earlier attempted suicide under section 309 was a punishable offense. Under Mental Health Care Act, it clearly said we are decriminalizing the attempted suicide. Under section 115 of the Act clearly says that a person who attempts suicide shall be presumed to be suffering from stress and will not be punished under the Indian Penal Code of section 309. However, the point is very clear. The person who is suffering from stress will be presumed to have stress. If the police is able to prove it is not because of stress and because of something else, still section 309 will be hold good. 309 is completely not squashed. Please do remember that. Coming to the critical evaluation of this legislation. Of course, Mental Health Care Act, a wonderful act, completely borrowed from the Western concept, where the individual rights takes precedence over the collective rights. That means person with mental illness will decide about his treatment and he will decide how long he will take, what type of treatment. He will decide about the advance directives, how he should be treated, how he should not be treated. And also he will name the nominated representatives. He may not even name any of the family members. That means rights of the individual takes precedence over the family members' rights. That means collective rights. And here again, in role of family in providing care, the family members play an important role. And hence, various studies have clearly shown expressed emotion plays a very important role in the outcome of various major psychiatric disorders like schizophrenia, bipolar affective disorder, obsessive compulsive disorder, depression. The family play a very important role. And in a country like India, where is a developing country, the family members are the main pillar of support for providing care. Unfortunately, the Mental Health Care Act completely ignores the role of family, and the family burden is enormous. Unfortunately, the Mental Health Care Act do not provide any kind of support to the family members in providing care. Neither any kind of pension is given to the family members for looking after a person with mental illness. Let's see how the state has taken responsibility with regard to person with mental illness in our country. If you look at this beautiful photograph or the figure in the picture, you clearly see that the state has very minimal role. The government provides mental hospitals, which are hardly around 40 in nature, and medical colleges and district hospitals. The all together maximum may come around 60,000 beds. This is what the state is providing. But however, the family takes a major role in providing treatment, providing basic needs, and rehabilitation. According to me, 99% is taken care by the family. Means the government is providing care and looking after them only in approximately around 60,000 persons with mental illness. But however, the prevalence of mental illness is around 10%. That means we have 13 to 14 crore population suffering from mental illness. They're all looked after by the family, not by the government. Hence, the role of family has been undermined and they have not been supported here. The family should have been supported under the Mental Health Care Act in our culture, in our country. This has been undermined. This has been a criticism, has been seen in various forums by the professionals. However, in the process of care, we have to see how the family members are going to provide care for a person with mental illness when he writes an advance directives and also the NR somebody else. However, the community treatment order is one which can be used to enable the family members in providing care for person with mental illness. To conclude, my dear friends, the Mental Health Care Act of 2017 is a major step taken to provide the rights of persons with mental illness. In this process, the rights of the family members have been completely ignored. The collective rights have been undermined over the individual rights. At the same time, capacity to consent plays a vital role in the Mental Health Care Act. And also advance directives, nominated representatives provides complete liberty and also enables the persons with mental illness. However, we need to know that this Mental Health Care Act provides many checks and balances, but at the same time increases the documentation of the work what the psychiatrists are doing. This documentation increase in time will cost more the care. That is basically there will be the charge or the services provided to persons with mental illness increases. Defensive practice is going to increase because person with mental illness can give complaint against the psychiatrist to the mental health review board if there is any violation or else if any treatment is given against the wish and will of the persons with mental illness, unless if there is capacity is lost and the NR gives consent. And also there are many hospitals may refuse to treat person with mental illness telling that they have not have any registration or else basically the license have been not proclaimed or taken. And also this manpower for providing care is very less in our country. That means the family members are the only people who are going to provide care for persons with mental illness. And family members need to be enabled by providing compulsory community treatment order so that person with mental illness takes treatment by the family members bringing him to the hospital whenever there is a chronic illness. Finally, Mental Health Care Act is a massive step in the right direction. This rights-based approach needs right amount of commitment from the state government, and also there is a need to enhance the manpower to fulfill the obligation of right to access for treatment, both IP, OP, rehabilitation, medications, and also geriatric and child care to be provided from community health center and upwards. And this obligation has been taken by the government through Mental Health Care Act. My dear friends, Mental Health Care Act is in force. Please do follow Mental Health Care Act. Thanks for giving your valuable time. Stay safe.